My name is Danny Goodman. I am the District Attorney General for the 29th Judicial District that covers Dyer and Lake County in Tennessee. I'm here today to talk to you a little bit about having a criminal offense expunged from your record. And I have a few slides put together, so I would like to show you those at this time. I want to talk to you today about expungement of criminal offender record, which can be found in Tennessee Code Annotated 4032-101G. First of all, we have to talk about an eligible petitioner because that's who can actually apply to have their record expunged. I'm going to go over a few things to tell you whether or not you are actually eligible. First of all, if you were convicted of 3 or more crimes arising from separate criminal events in any city, county, or state, so it doesn't just have to be in Tennessee, then you cannot have any convictions in Tennessee expunged. So once you have 3 crimes or more that happen on different dates, you do not qualify to have anything expunged from your record. You must have completed all terms of imprisonment, probation, or parole. If the sentence included probation or parole, the sentence was not completed until the end of the probationary period. And what that means is if you had a sentence of 3 years of supervised probation, your time period that you start calculating when you're eligible does not start until you end your probation, and you have to end that successfully before you can do that. That means you have to have all fines paid, any court costs, any fees that may be out there, community service, all of that has to be successfully completed. The time period for filing the petition is once you have completed that, you have to wait 5 years from the day you complete the probation or you complete the sentence if you completed the sentence in full in imprisonment or jail. That is for a misdemeanor or a Class E felony. There are some Class D and C felonies now that are eligible to be expunged, but for that you have to wait 10 years from the time that your sentence is completed before you can apply for expungement. Now, we talked about the fact that you could not have 3 or more offenses. I'm going to tell you what you can have now to actually have your record expunged. You can have 2 convictions of separate incidents. That means that they happen on different dates. You can have 2 incidents expunged from your record, but it has to be a specific type of incident. First of all, you can either have 2 misdemeanors or you can have 1 felony and 1 misdemeanor. Those are the only ways that you can have two actual incidents expunged. The same time period applies. It has to be 5 years if it's a misdemeanor or an E felony. It has to be 10 years if it's a misdemeanor plus a D or C felony. If you are seeking expungement of convictions for more than one of the offenses listed in this subsection, which is the section that talks about expungement, the conduct upon which each conviction is based must have occurred contemporaneously at the same location, representing a single continuous criminal episode with a single criminal intent, and all such convictions must be eligible for expunction under this subdivision. What that means in simple terms is you can have more than one offense expunged, but they had to arise out of the same event. It had to be on the same date. It had to be at the same location. So an example of that is if you had a burglary and a theft, and they all occurred at the same time, but you were charged with 2 different crimes, you can have both of those expunged, even though it's more than 2 felonies because they happen at the same time. You can have more than just the one expunged from your record. Also, if you're required to do so by any conditions that were set a part of your sentence, whether they were issued as a part of the sentence from the judge, if it was a condition of probation, that you must remain free of alcohol dependency or any type of controlled substance, you have to prove that you have not had any dependency or any substance use for the past 1 year. Now, when we talk about what can be expunged, the statute has set out what is called an inclusion list. Inclusion lists are there for felony charges. That means anything that is on this list that's included in the list can be expunged. So if any of these offenses or any that you have committed These are charges that you may actually have expunged from your record. We start off with Class E felonies, and we have more Class E felonies than we do of the D's and C's. But this is a list, and you can find this list in the statute, or you can, I've listed all of them on the videos. If you're able to pause the video, you may be able to look to see if you see the offense you're looking for. But there are numerous Class E felonies that are listed that can be expunged from your record. Now, also Class D felonies may now be expunged. This is something that was not originally there. Originally, the only thing that could be expunged were Class A misdemeanors and Class E felonies. There have been some recent changes to the statute that now allows Class D and C felonies to be expunged. These are, once again, the inclusion list. So this means these are the ones that are included that can be expunged. So you see there are not quite as many D and C felonies as there are E felonies, but there's still quite a few here, and it covers a lot of different offenses that may be there. And once again, these are the C felonies that may be expunged. And once again, it's a fairly inclusive list that does have numerous offenses. Now, the only thing about this is a person is not eligible to an eligible petitioner if the person was convicted of an offense involving the manufacture, delivery, sale, or possession of a controlled substance, and at the time of the offense, the person held a commercial driver's license, or the offense was committed within a motor vehicle, or any driver's license, and the offense was committed within a commercial motor vehicle. So if you have a commercial driver's license and you committed any of the offenses of manufacture, deliver, or sale of a possession of a controlled substance, then you're not going to be eligible to have those offenses expunged. Now, the misdemeanor list is a little bit different than the felony list. The felony list was an inclusion list, which names all of the offenses that are included that may be expunged. Misdemeanors are just the opposite. This is an exclusion list. The way they did the misdemeanors is you may have any misdemeanor expunged from your record with the exceptions of the ones listed. So this is an exclusion list. So if you have one of these misdemeanors, they do not qualify to be expunged from your record. And this is a more extensive list than the others. So I'm going to leave these up just briefly so that if you do need to pause the video, you can do so and see if you have an offense there that is not included. Now, when we're talking about these offenses that may be expunged, we have to look at two different time periods. The sentencing law in Tennessee changed in 1989. So we have to look at the offenses that occurred before November 1st of 1989 and then after November 1st of 1989. All of the offenses that I just talked to you about are offenses that occurred after 1989. If you have an older conviction and it was before November 1st, 1989, these are the qualifications you have to meet. First of all, that you were sentenced with either a determinate sentence or a 3-year or less sentence, or sentenced to an indeterminate sentence for which the person served 3 years or less. We don't use determinate and indeterminate sentences anymore, so you will have to go back to the paperwork that you had at that time. The convicted person never had a previous conviction expunged, so you've never had any other expungements. This is your first one. The offense did not have an element that included the use or the attempted use of any force, physical force against another person. The convicted offense did not involve, by its nature, a substantial risk of physical force against another person. The convicted offense did not involve the use or possession of a deadly weapon. The convicted offense was not a sex offense for which the offender was required to register with the sex offender registry. The convicted offense did not involve death, serious bodily injury, or bodily injury to a person. The convicted offense did not involve the use of alcohol or drugs in a motor vehicle. The convicted offense did not involve the sale or distribution of Schedule 1, 2, 3, or 4 controlled substance. the convicted offense did not involve a minor as the victim in the offense, and the convicted offense did not result in causing the victim or victims to sustain a loss of $50,000 or more. So once again, the only time that you're going to apply these is if this is a crime that occurred before November 1st of 1989. Now, the process that you're going to have to go through if you want to expunge your record is the first thing you have to do is you have to get a petition, and you should be able to pick this up at your local district attorney's office. When these expungement laws were passed, included in that statute was that the district attorney was to create a form in their office for people to be able to apply. So it may not look just like this form. This is the one that we use in our district, but it will be a form similar to this. So you go to your district attorney's office, get the petition, fill that out. This is the second page of that petition. You're going to sign that, put your mailing address and any information that they request, and then you're going to bring that back either to the district attorney's office or take that to the clerk's office and file that. Once you do that, the district attorney is going to review that to find out whether or not you qualify. This is another request that is also available. It's on the state website. This is a request for removal of criminal offender record. So this is something else that may be able to be used rather than a petition. We actually are using both of these. Once the district attorney reviews that, if he finds that you are an eligible petitioner, then he is going to complete this order. And this is an order granting petition to expunge records of conviction. So basically this order just says that they are approving the petition that you filed. It states that it lists all of the requirements and that you agree that all of these requirements have been met, and it will be signed by the judge. This form will be sent to the clerk's office to have your record removed in the local system. It will then be sent to the Tennessee Bureau of Investigation to have your record removed from the system that they have, which is nationwide. You have to give the Tennessee Bureau of Investigation up to 60 days to expunge your record once they receive this order. In addition to this order, there is a second order that will also be completed. This will be signed by the district attorney, by the defendant or the defendant's attorney, and also by the judge. This is the form that actually goes to the Tennessee Bureau of Investigation, and it tells them what charge to expunge. It has the date, the docket numbers, and all the information they need to make certain they have the right form. Something that you can also attempt to do if you do not qualify for expungement is to file a petition to have your record expunged by pardon. So you can always request the governor to give a pardon to the offense that you have. And if the governor does grant that, and this is the order that would come out saying that you were granted an order of a pardon, and that this would be the petition that we would actually, in the order that we would actually submit, stating that you've been granted a pardon and that your record should be expunged. So that's also another option if you do not qualify. Last thing that I want to tell you is do not be discouraged. If you don't qualify under these requirements that I've listed here, don't get discouraged, don't give up. The legislature amends this statute all the time. When it first came out, there were very few offenses that could be expunged. Since then, almost every year or every other year, they add additional offenses that can be expunged. They've added different class crimes that may be expunged. So just don't be discouraged if you don't qualify right now. The new amendments take effect July 1st every year. So just stay on top of that. Keep up with the changes in the law. And if you realize that you now are eligible, come back and file that petition. If you have any questions about how to file the petition, if you have any questions about whether you qualify, whether there have been any changes, contact your local district attorney's office. They can help you with that. And they can also help you with the process of filling out the application and getting this process started for you. I hope this information has been helpful for you. And if you ever need any assistance, don't be afraid to call your district attorney. They're there to help you. Thank you.